Hey everyone, welcome back to episode 964 of Money Girl. I appreciate you spending some time with me and downloading the show. If you're new here, I'm Laura Adams, an award-winning author, on-camera spokesperson, money speaker, and founder of The Money Stack. That's my Substack newsletter. Subscribers automatically receive my Money Success Toolkit, which includes the exact templates I use to manage my finances. So I hope you'll check that out. You can learn more, ask questions, and sign up for free for The Money Stack when you visit lauradadams.com. And if you've got a message you want to leave me, you can also call 302-364-0308 and leave your message. I would love to feature your question on a Finance Friday show. That's our weekly Q&A bonus edition of the show that comes out on Fridays. If you've ever wondered what happens to your or someone else's debt, like mortgages, student loans, auto loans, and credit cards after you die, this podcast will review what you need to know. You'll learn about situations when surviving family members can and cannot be held responsible for repaying creditors. So before we can talk about debt and death, we really need to understand something called an estate. So after you die, everything you leave behind becomes a legal entity called your estate. Estates are not just something that wealthy people have. An estate is, again, it's what you leave behind. It could be small or it could be huge. It's going to include things like your cash accounts, all your financial accounts, your investing accounts, your real estate, your assets like vehicles, your personal belongings, and of course, your debts. Now, what happens to your estate depends on whether you die with or without a last will and the state where you lived. And probate is the legal process where a court reviews and validates your will if you have one, and they oversee the settling of your estate. Every estate must have a named executor whose job is to distribute your property and pay your outstanding debts like bills, loans, and of course taxes. Now, if you don't create a last will with an executor, a court will appoint one for you. And the problem with that is they likely won't be someone you know, and they may not carry out your wishes as you would have liked. So if you don't have a will, I want to strongly encourage you to prioritize creating one. Every adult should have a will. Again, even if you don't have much in the way of personal belongings or assets, everyone should have a will. And you can hire an estate planning attorney to do that, or you can use online resources like Trust and Will or Rocket Lawyer. I'll put a link to those resources in the notes for the show. So let's keep talking about what happens to debt after death. I think many people have misunderstandings about what happens to their own debt or maybe somebody else's debt after death. I want to go through a few incorrect statements that I've heard people say about debt and death over the years. I've heard people say, oh, all your debts just disappear after you die. I've heard it said that your children inherit your debt after you die. I've heard it said that you have to pay off a close relative's debt if they die. And I've heard somebody say, yeah, you have to purchase life insurance to pay debts after your death. None of those statements is 100% true. As I mentioned, a deceased person's debt becomes part of their estate. However, if you have federal student loans, that's kind of a unique situation because they are automatically discharged or disappear when you die. But that is not the case for private student loans or any other type of debt. Therefore, with the exception of federal student loans, if there is not enough cash in your estate to pay off what you owe, the executor must sell as much of your property as possible to cover your debt. For instance, if there isn't enough to pay off your credit cards and personal loans, your executor may need to sell your belongings or non-retirement investments to cover them. However, in most states, certain assets like funds in tax-advantaged retirement accounts are safe from liquidation to pay creditors. Therefore, if you name your spouse or a child as the beneficiary of your 401k or 403b, they would receive the money even if your estate were insolvent or broke. Creditors also can't go after property or cash that goes directly to someone else when you die, such as the beneficiary of your life insurance policy or even an annuity. Those funds belong to your beneficiary and they do not belong to your estate after you die. After your executor pays your debts, and they have to pay them in a priority order set by state law, such as paying off funeral expenses first, then taxes, then your other debts. After doing that, they distribute the balance of your estate assets to any beneficiaries listed in your will if you have one. For instance, let's say you have a home with a mortgage and your will says it goes to your son. Well, if you die and your son accepts the property, he will be responsible for the mortgage payments. And that's, kind of a unique situation. There's a federal law called the Garn-St. Germain Depository Institutions Act that allows a close relative who inherits a property to assume payments on the mortgage without triggering a due on sale clause. In other words, your son could title the home in his name and make payments, even if the mortgage remains in your name after your death. So real estate is a little bit different than other types of inherited property. However, if someone inherits your real estate and they can't afford it, they can't afford the expenses, including the mortgage, homeowner's insurance, property taxes, they'll need to sell the property or they risk foreclosure from the lender. So let's suppose an estate has more debts than assets. In that case, your creditors are generally out of luck, especially if the debt is unsecured, like credit cards, personal loans, private student loans, and medical bills. So I hope that will put your mind at ease if you've been worried about a family member racking up debt and thinking, oh my gosh, I'm going to be responsible for that one day. No, again, if someone's estate can't cover the debt that's in their name alone, creditors can't attempt to collect it from their family members. Creditors have a limited period, such as up to 6 months, to make a claim against an estate. It's against the law for a creditor to prey on a deceased person's relatives, hoping they'll feel duty-bound to pay somebody else's debt. Remember, the deceased person's estate is typically responsible for their debts, not you. Now, let's talk about some situations where you may be responsible for someone else's debt after they pass away. For example, let's say you co-signed a debt. Maybe it was a mortgage. It could have been a student loan, an auto loan, or a credit card. If you co-signed a debt with the deceased, it will now be in your name. You are going to be responsible for it, even if, let's say, you never made a charge on a co-signed or joint credit card. You're still legally responsible for 100% of the debt. So that's why co-signing should never be taken lightly. Note that being an authorized user on a credit card is different from co-signing. For instance, let's say you're an authorized user on your dad's credit card and he passes away. Well, in that case, you're not responsible for the debt, even if you made many charges on the card, because an authorized user has no legal responsibility for a debt, only a cosigner or a joint account owner. So be clear about your credit card ownership status if a debt collector comes knocking. Again, unless you're a cosigner on someone's account, their debts are not your problem. However, an exception known as filial responsibility applies in certain states, which may obligate adult children to pay for a deceased parent's unpaid medical debts when their estate is unable to cover them. However, whether that law applies depends on factors like a parent's age and a child's financial situation. Now, if you do have co-signed debts, a solution to ensure that the survivor can repay them is to take out term life insurance and name the co-signer as your beneficiary. That would protect them financially if you die. However, there's no obligation to purchase life insurance to cover your debt after you die. Now let's talk about what happens to debt when a spouse dies. When you're married, what happens after the death of a spouse depends on whether you live in a common law or a community property state. There are just 9 community property states. I'll list them. They're Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, and Wisconsin, and in Alaska, spouses can opt into the community property system. So in community property states, money earned and property acquired by either spouse during the marriage are owned equally by both of you. Likewise, your debts are shared. So even if your spouse, let's say, had a secret credit card in their name only, you would generally still be responsible for the debt in a community property state. However, property and debt you owned before the marriage are not considered community property. So, for instance, let's say you took out a private student loan before you got married. In that case, your spouse would not be responsible for it if you died in a community property state. Additionally, you can sign a legal document like a prenup or a postnup agreement to separate some or all of your community property. In common law states, debts in one spouse's name are not the responsibility of a surviving spouse. For example, if a deceased spouse's name is on a credit card that you didn't know about or a car loan and title, you likely wouldn't be responsible for it. However, there is an exception if funds were used for the benefit of the family, such as paying for food or childcare. In that case, you could be held responsible for 100% or even 50% of the debt in a spouse's name, even in a common law state. But again, the treatment of debt after death can vary slightly, even among common law states. So the state law is going to vary. So it just is going to depend on where you live. Now, to sum up, with a few exceptions, such as being a cosigner or being married in a community property state, family members are not responsible for a deceased person's debts. So never rush into paying a deceased person's debt from your own funds. Creditors just may not receive payment if an estate has more debts than assets. If you need help planning your estate, managing one for a deceased family member, or you've got questions about debt, I want to encourage you to consult with an attorney licensed in your state. That's all for now. I'll talk to you soon. Until then, here's to living a richer life. Money Girl is a quick and dirty tips podcast, and we've got a great team that works on the show. Steve Rickyberg is our audio engineer. Holly Hutchins is our director of podcast. Morgan Christensen is our advertising operations specialist. Rebecca Sebastian is our marketing and publicity manager. And Nathaniel Hoops is our marketing contractor.